She's referring to a case that was brought under federal law in the 1990s with a British national living in Australia who was offended by a national newspaper regularly referring to the poms and the pommies, and lodged a complaint under the Racial Discrimination Act and claimed to be distressed about the adverse portrayal of the English as whinging. So, Tim, if I can start with you, is this the type of case that the RDA is designed to address?
Well, it goes to what Peter was saying about a matter involving serious and profound effects rather than mere slight. So I think that gets to the heart of what the law is intended to protect people from. But I think it's important to understand as well that the law does not anywhere say that it is there only for minorities or for people of particular backgrounds. That's not the language in which the law is expressed. And that's because the interest that the law tries to protect, and this word has been mentioned already, is the dignity of persons. And also, I think, the entitlement that every member of society has to enjoy equal standing in the ability they have to participate in society. So I think if we want to go back to first principles to understand what the law is attempting to protect or to carve out as a realm that the law should guard, they're the sorts of interests that we're talking about. And let's touch on the idea that one can have a sense that one is inferior, and I think that's a relevant consideration here. Social power must enter the equation at some point, and I think the law is guided by considerations of that, if not necessarily in the letter of the law, then at least in its spirit as well.
Following on from that, from what you just said there, now, Les, if we substituted in that situation a pom with a reference to an Aboriginal person, so there could be that power, difference of power that Tim was talking about. Do you think the RDA never provides a remedy? Do you think the RDA should provide a remedy in that situation?
Well, it actually comes right on to an interesting set of discussions we had with the Attorney General about this, and we haven't said much tonight about the fact that this is basically looking at civil law under 18C is in relation to civil laws. And when the Attorney General was saying, well, can we look at some options here about the words that are used in 18C? Can there be better words, or better suited words, and so on? And at one stage, I think we even contemplated the fact, well, if there was if it became a criminal offence, would there be a need for 18C as a civil offence? Well, the answer is exactly that, the remedies. And in this case, with this British person, if it had been an Aboriginal person, chances are, I'm sure experience has been, that they would then go and quote that section of the Act and go to the Human Rights Commission or the state-based anti-discrimination bodies and say, I'm deeply offended by this and I don't want any more of this and so on. And it would start this mediation process with the person who was offending, and that most of the matters are resolved that way. They're not actually going off to court. In fact, I think on the figures that Tim mentioned before, I think it's something like 5% of the cases actually end up in litigation to be resolved. 3%, yes. And so the idea of having a remedy of that nature is so important that, again, the 18C is there, Section 18C. But what it does is it triggers this approach with the Human Rights Commission, which involves the mediation and set process, and where parties from both sides can sit down and resolve those matters. And I think that's the good result. I think that's the sort of thing we like from laws and resolving disputes and so on doing it. And I'd have to put it up there to say that I think that in the situation of an Aboriginal person was having a similar sort of a grievance, yes, they would take it up, they would feel offended. And I think even going back to some of the Facebook references we were making before, that's what's happened with Aboriginal people, that they see something that's hostile, vilifying on the Facebook site, and they start to organise and complain about it. They get rejected and so on. They keep on complaining about it, and eventually the site will go down. In this case, it wasn't necessarily mediation with the person that was offending, and sometimes we've seen them pop up again. But nevertheless, I think we do see that remedies operate, and I think that we shouldn't disregard the fact that ADC exists. That's not why those remedies are occurring. I think that's a big part of it.